So my name is Marnie Layon. I am a Deputy District Attorney for the County of San Diego. I have been with the San Diego County District Attorney's Office since 1997, with a little stint in the middle there in early 2000s, working part-time, taking a 2-year sabbatical, raising little kids who are now 21 and 19 and in college. So I have been in the Family Protection Division of the San Diego County District Attorney's Office in the aggregate for about 10 years. I do work in North County, and I am one of the team leaders for the Family Protection Unit up here in North County. So what I'm going to talk to you about this evening is mandated reporting requirements for healthcare staff. So there was healthcare amendment that I was talking to you about in summer second was going on as our district attorney in the ceremony, and I think you can tell earlier this meeting, when you hear something said to the law, you will remember and dial it over. And there was a particular thing I can't even remember, and talked about a story, but I think it's very fitting to the work that we all do. And so it's something I want to share with all of you. There was a story told about an elderly gentleman who was on a beach. And there was a younger man, a father with his small son, walking on the beach. And he watched the elderly gentleman for some period of time, going over and picking up one of thousands of starfish that were washed up on the beach. And he would gently pick each one up and walk out to the water, maybe place the starfish in the water. And the reason he's doing this is because they're all basking and trying to right now. And the father and his one son watched the elderly gentleman for a period of time. And at some point, the father went up to the elderly man and said, "Why are you doing that? You know you can't help him and say enough." And the elderly man looked at his hand at the one starfish he was holding. And he said, "But I can take this one." And that's what all of you do every day. You hold a patient in your hands and you save that one. And I know for me, the kind of work that I do, and I know all of you that are here, because you do the same kind of work, that one in your hand is very important. And I just want to tell you how much I appreciate all you do. Anyone that knows me knows that I am in awe of the medical personnel that I get the opportunity to cross paths with and work with from time to time. I'm in awe of what you do. You save lives, you make a difference. And so thank you for that. So we're here to talk about suspicious injury reporting and who must specifically report. And that is found in the Penal Code, Section 11161. It's any healthcare practitioner employed in a health facility, clinic, physician's office, local or state public health department, or a clinic or other type of facility operated by a local or state public health department. It includes any physician or surgeon, anyone who provides medical services to a patient for a physical condition that he or she reasonably suspects is suffering from a firearm wound, whether it's inflicted by the patient or by another, or is suffering from any wound or other physical injury, whether injury was the result of assaultive or abusive conduct. There is a list of offenses that are included in this subdivision, and most of them are going to be obvious, but there is a list because lawyers like to make lists when they include things in legislation. So the list is inclusive of murder, manslaughter, mayhem, torture, assault with intent to commit mayhem, rape, sodomy, or oral copulation, battery, sexual battery, incest, assault with a deadly weapon or caustic substance, assault by means likely to produce great bodily injury, rape, human trafficking, child abuse or endangerment, abuse of spouse or cohabitant, domestic violence, sodomy, lewd act upon a child, oral copulation, sexual penetration, elder abuse, or an attempt to commit any of the listed 23
crimes. What injury does not include specifically is any psychological or physical condition brought about solely through the voluntary administration of a narcotic or restricted dangerous drug. There are other state reporting mandates which preempt the use of suspicious injury reporting, and those include child abuse, elder abuse, sexual assault of adult, sexual assault of child. It's important to understand that when two or more healthcare providers have the knowledge of a suspicious injury, suspected instance of violence, if it is required to be reported, only one person of the team needs to submit a report. Not everyone has to. So there are steps laid out how to make such a report. It's important to inform the patient that the report is being made. And we're going to talk a little bit later about how this can be handled in a manner that's consistent with being trauma informed, because intuitively, if you've got a patient that does not want this reported to law enforcement, it becomes complicated how that can possibly be done. But we're going to address that later in our presentation. The second step requires the report of the injuries to local law enforcement agency by telephone immediately or as soon as is practically possible. It's important to call the law enforcement jurisdiction where we believe the incident occurred, which may be different from where you are treating your patient. There is an entire Cal OES 920 form. I'll show you a sample of it in a moment. And it is important that that gets completed as the final step, and it is faxed within 2 working days to the law enforcement jurisdiction where the incident occurred. And you all have probably seen this form before. This is what the form looks like. It has all of the important information that needs to be included. I pause for a moment when I talk about this form to make sure that we get accurate information from the patient, especially on their address and especially on the good phone number that is the number they can be contacted at. It's important to find out if this is a safe number to contact them at, especially in the case of domestic violence. And one of the reasons I point this out is I know you, as medical care providers, you need that important accurate phone number in case you need to follow up with the patient to get them lab result information or follow-up test information. And I know you know that sometimes patients provide phone numbers that are not accurate. The other reason that's going to become very important later for us at the district attorney's office is in the family protection division, which a lot of these suspicious injuries come from. We have a policy that we reach out and contact every victim on every domestic violence or family protection case that is submitted to us for review while we're in the process of making an issuing decision, so that that victim is not left with the worry that this is a runaway train, that they will never get an opportunity to talk to someone and give their input about what they think should be happening. We reach out and contact everybody. If we don't have a good contact number, that makes it impossible for us to do that. And we do care a lot about making sure that we are giving that victim the opportunity for their voice to be heard. The report shall include the name of the injured person if known, the injured person's whereabouts, the character and extent of the person's injuries, the identity of any person the injured person alleges inflicted the wound, if they say, or assaultive abusive conduct upon the injured person. It is important to know who they are saying did this. It's recommended that any medical records of a person they are reporting about do include any comments by the injured person regarding the past domestic violence or regarding the name of any person that's suspected as doing it. A map of the injured person's body showing and identifying injuries and bruises at the time of the health care, and a copy of the law enforcement reporting form. It's recommended that the physician or surgeon refer the person to local domestic violence services if the person is suffering or suspected of suffering from DV. We feel that this is very important. As all of you know, domestic violence victims are very frequently cut off from family and friends, because in order to continue the abuse, an abuser needs to be the only emotional person in that victim's life. What is important about getting them resources as soon as possible is if their abuser has already been arrested and they are now cut off from the only emotional outlet they have, it's very important to reach out and get them resources as soon as possible, because we want to make sure they know they're not alone. It is, again, recommended that we want to encourage them to provide accurate contact information so that they can continue to give their input and have their voice heard by the DA's office, who ultimately will review any criminal case submitted. It is recommended highly that victims are informed of the domestic violence assault forensic exam, that it is available at no charge to them through Palomar Forensic Health Services. It is voluntary, so if it's not something they want to do, of course they don't have to, but we want to make sure we let them know that's another resource that's available. This is especially important in any instance where the victim has reported a strangulation event. When law enforcement arrives at the hospital to take the victim's statement, they can make arrangements to schedule the DAFI exam for them. In any court proceeding or administrative hearing, the physician, patient, and psychotherapist privileges do not apply to the information that is required to be reported in these sections. Suspicious injury reporting is the law. Healthcare staff have a duty to report suspicious injuries to law enforcement. It is a misdemeanor not to report them. Civil and criminal immunity is provided to health practitioners who make required or authorized reports pursuant to these provisions. You do have an ethical responsibility to report. You have a window of opportunity to reach families in need and prevent future violence and abuse. We can ensure the victim receives connections to hotlines and service providers that can help with safety planning and local resources before he or she even leaves your office. There is immunity from liability. A health practitioner who makes such a report shall not incur civil or criminal liability as a result of any report required or authorized by the article. No civil or criminal liability for taking pictures of the injured person, causing photographs to be taken, or disseminating such photographs to law enforcement will be prosecuted either. No civil or criminal liability for granting access to the victim to local law enforcement or APS who has requested access. No employee shall be discharged, suspended, disciplined, or harassed for making a report pursuant to this subsection. And the section does not apply to mandated reporting of child abuse. That does get covered in a different presentation. Now, I told you earlier that I understand that there can be a dilemma that is brought up when we explain that to the patient. I suspect that this is an injury that was caused by abuse, and I am required to report it to law enforcement when the patient, for a multitude of very valid and understandable reasons, does not want it reported. How can we possibly conform with being trauma informed while complying with the obligations under these sections? And I know that this phrase has been out in our professions for many years now, but I do want to approach and touch on what trauma-informed approach is. It is a strength-based framework that is grounded in an understanding of and responsiveness to the impact of trauma. It emphasizes physical, psychological, and emotional safety for both providers and survivors, and it creates opportunities for survivors to rebuild a sense of control and empowerment. There's not a common definition of trauma-informed care, but it should strive to create a definition that includes the following: an awareness of the prevalence of trauma, an understanding of the impact of trauma on physical, emotional, and mental health, as well as on behaviors and engagement to services, and an understanding that current service systems can re-traumatize individuals, especially when we're required to reach out and do a mandatory report for suspicious injury when the victim does not want that to happen. A trauma-informed approach, we want to make sure that it is including the 4 R's. Realizing the widespread impact of trauma and understanding the potential paths for recovery. Recognizing the signs and symptoms of trauma in clients, families, staff, and others involved in the system. Responding by fully integrating knowledge about trauma into policies, procedures, and practices, and seeking to actively resist the traumatization. So again, when we ask someone to be trauma informed and we ask them to follow the mandatory reporting requirements with a patient that does not want that to happen, how can these two things coexist? So this is where I think that the requirements under Marcy's law and the policies of the district attorney's office will be helpful to you, because they're going to help you be trauma informed while doing something your patient has just told you they don't want to have happen. Under Marcy's law and Proposition 9 and the California Constitution, a victim of crime has the right to have their opinions about prosecution of their case to be heard and considered. It's the law in our state, and the district attorney's office takes that obligation very, very seriously. It is the policy of the Family Protection Division of the district attorney's office to make efforts to contact all victims of crime, especially domestic violence cases that fall in the Family Protection Division, which is also going to include elder abuse and child abuse, physical and sexual abuse, prior to making any issuing decision in cases submitted to our review. The purpose of that contact is to provide the victim an opportunity to express their feelings about whether or not criminal charges should be filed, what they want to see happen as a result of the conduct that they are a victim of, and to ensure that any questions they have about the process are addressed, and to provide information regarding victims' services. Again, I include encouraging victims to provide accurate contact information. We think it's important to let victims know when they're being informed, I have to report this to law enforcement. It's important to let them know, and we think this gives you the ability to then be trauma informed, because you're sharing with the victim, you're going to contact law enforcement. Law enforcement may or may not submit a case to the district attorney's office for review, but this is not a runaway train. You are not going to suddenly be told, we know you don't want this reported, we have to, and that's the end of the conversation. It's important to let them know. The DA's office is going to reach out to you. They care about what you think. And in my experience, having done thousands of calls like this in my career, almost all victims of crime believe once they hear law enforcement and the DA's office are involved in any way, their loved one's going to jail. Could not be farther from the truth. It is not uncommon for low-level felony cases or misdemeanor cases that no one's interested in seeing the abuser go to jail. We're interested in getting the abuser the help that they need to ensure that conduct like this doesn't happen in the future, and we're not interested in jail at all. And the way these conversations go when I do them is I first listen to what the victim wants to have happen. I let her explain what she thinks should happen, or he. I let the victim explain what their fears are and what they want to have happen moving forward. More often than not, they tell me that their loved one needs help. Either they have mental health issues, they have substance abuse issues, they have alcohol issues, or they have issues controlling their anger, and they are sometimes violent with the victim. What I then usually am able to tell the victim is, more often than not, I'm in agreement with what the victim thinks should happen. I think that the abuser needs help as well, and I think they deserve an opportunity to get well. Obviously, in more serious cases, I may sometimes have to tell the victim that we may have to agree to disagree about what to do next, but that I'm always open, willing, and interested in hearing what they have to say, and that it matters to me, even if I don't agree it's the right way to go, what they think is important, because this affects them greatly. And I think if you are armed with that information, knowing how the district attorney's office is going to treat them, that may help diffuse some of the fears that they have about law enforcement being brought into their lives when they don't want it. It's not a runaway train that they no longer have to say about. We care about what they think, and they are going to be treated with the respect that they deserve, and they're going to be heard out, even if we may not agree what the right course of action is. As I've indicated multiple times, they do have a right to be heard, and we have an obligation to listen. So I hope that talking through what the different requirements are for mandatory reporting with suspicious injuries, and then coupling it with this trauma-informed approach by letting your patients know that there are steps that are going to follow. Law enforcement is going to be contacted. Law enforcement will then decide whether or not to submit a report to the DA's office. If they don't submit a report to the DA's office, nothing further will happen on the case. If they do submit a report to the DA's office is going to reach out and listen to them. We're going to hear what they have to say. We're going to make sure that we are being trauma informed with how they're treated, so that the conversation doesn't have to end with, I know you don't want me to report this injury to law enforcement, but there's people who care about you. There are victim advocates who are interested in helping you. You're not alone. And there are lots of people who just want to help keep you safe. Hopefully that is going to make taking care of that one patient that's in your hands, it's going to make it easier for you to be able to do that in a trauma-informed way, especially when you're dealing with a patient who has been traumatized and is very frightened about having law enforcement or the district attorney's office later involved in their lives after you have taken care of all of their medical needs. I don't know if we have time for questions, but I am delighted and happy to answer any if we do. And I have provided my contact information here in this slide, the last one. I'm happy to talk with anyone anytime. I'm more than happy and delighted to answer any questions if anyone wants to reach out to me at any time in the future. And I do appreciate you giving me your time. I know that your time is very important, and I'm always really excited when I get to talk to people in the medical field, because I do continue to be in awe of the work that you do, and I'm honored to be allowed to speak to you this evening.
Thanks, Marnie. There's a question in the chat with assault that happens across the border. Any recommendations on reporting for those situations?
So if we're hearing about an assault that happens outside I'm assuming when you say the border, you mean outside the United States in Mexico?
Right.
Cool.
Sorry.
Given that it is outside our jurisdiction and there would be no one for us to report that to, I don't believe there is a requirement to report to an agency in Mexico. However, I think it would obviously be very important to get that victim the help that they need as far as resources, counseling. They may need shelter. They may need resources about getting a restraining order here in the United States, which they would be able to do. And I know that it's not up and running yet, but I do know that we're all very, very hopeful that one safe place is the Family Justice Center that we do hope to be opening in San Marcos sometime in the coming months. It will kind of be a one-stop shop for all of these issues. And I would think that although I do not believe there is a mandatory reporting requirement, I could be wrong on that, but I don't believe that it's required and I will follow up if I find out to be differently. But given that that San Diego County does not have any ability to prosecute crimes that don't occur in our jurisdiction. So for instance, if a crime happened in Riverside, I think that the mandatory reporter could report to the jurisdiction in Riverside. So for instance, if it was the sheriffs in Riverside, they would be able to make that report. But I'm assuming based on the nature of the question that it is with regards to outside of the country. But again, I think the most important thing to make sure is that we're getting the victim all the resources that they need. And when we do get that Family Justice Center up and running, the resources, at least in North County, there's already one down in downtown that would address populations that would be closer to that location. But the best part about that is that we get a one-stop shop for all those resources that victim is going to be needing. And we do want to make sure that all those issues get taken care of.
Thanks, Marnie. There's a follow-up question that does that change if the perpetrator is an American citizen?
It does not as far as jurisdiction goes. We would not have the ability to prosecute an American citizen who's committing a crime in Mexico. Okay. But obviously Mexico would have the ability to do that if they chose to.
Thanks. And then Alicia has a question, but I think that's going to be answered with our second presentation about the difference between mandated reporting with children. So our next speaker is child welfare, and Shlyn's going to cover that for us. I did have a question about the personal safety, like cards. Do you have a resource with the district attorney's office? Because we were thinking about streamlining those, and I don't want to reinvent the wheel.
So we have a lot of pamphlet information that we have. I haven't checked recently to see if we have one that addresses that issue, but I can't fathom that we don't. If I had someone smarter than me, one of our victim advocates online right now, they'd be able to answer immediately. They're the experts on all those issues, and I can find that information out. I would be very surprised if we did not have that information. I'm assuming that we do.
And if you could put us in touch, that would be very helpful.
Of course, absolutely.
Thank you so much. If we have follow-up questions that trickle in, we'll make sure that we get those addressed. I'd like to transition to Shlyn's, and please correct me if I'm saying your name wrong, but I just wanted to make you co-host real quick.
Thank you. You're doing a great job, Shlyn Guarian.
Thank you. Thanks. So I'm just going to make you a co-host real quick.
Thank you.
And just jump in when you're ready. So Shlyn is with the Child Welfare Services, and we really appreciate your time tonight. I know it's and not your usual time slot. And we have some thank you notes while she's getting ready for that I'm going to share in the chat window. If you could sign those, that would be really helpful.
Are we ready? Should I just go ahead and get started?
Yeah, if you want to give us just a brief introduction so that we understand what you do and your perspective.
Okay, sure. All right. Hi, my name is Shlyn Guarian, and I'm a senior protective service worker with the County of San Diego Health and Human Services Agency, Child Welfare Services, and I'm also the Community Outreach Liaison. And so thank you very much for having me here today to present to you on the child abuse mandated reporting. My goal is to improve communication with our agency, of course, with our community partners, increase collaboration so that we can achieve safe, healthy, and thriving children, family, and communities, striving to reduce the overrepresentation of African American, Native American, and Latinx children in child welfare services by increasing the cultural awareness and responsiveness of our regional staff internally, our community partners, and our service providers. I don't think it's going to let me see. Okay, there we go. And so during this mandated reporter training, our agenda is to cover the Health and Human Services Agency and Child Welfare Services vision and values so that you can know what that is, the mandated reporting laws, the process of filing a report, the types of information that you need to gather when you're considering filing a report with Child Welfare Services, and then the types of abuse and neglect that's outlined by the California Penal Code, and the consequences for failing to report, and what happens next after a report is filed. The Health and Human Services Agency is one of 4 groups or divisions of the San Diego County government. Within the County of San Diego, we have a vision that every one of its 3.3 million residents live healthy, safe, and thriving, working with our community partners and service providers who are Live Well San Diego partners and beyond, to make people's lives safer, healthier, self-sufficient by delivering the essential service of San Diego County. Within Child Welfare Services, we have a practice framework called Safety Enhanced Together. We refer to it as SET. We have a vision that every child grows up safe and nurtured, with our number one priority when children come and families come to the attention of our agency is for children to remain at home, to work with them to stabilize and preserve those families. And when that's not possible, and we're not able to keep children safely in the care of their family, of course, we're going to continue providing care to those children and looking to reunify those children to their families of origins as soon as possible. And if that's not possible, we're always working to establish, and maintain those permanent relations, the lifelong relationships for children and youth. Within Child Welfare Services, we have 6 core values that serve as the cornerstone for Safety Enhanced Together, and they guide our daily practice and support of strengthening families. Today, we're going to focus on shared responsibility with our community partners, such as yourself. The guiding principles of this value is that the shared responsibility with our community partners to ensure community resources are accountable, responsive, and culturally sensitive, identifying and strengthening informal and formal resources in every community. Services are evidence-based, as Marnie talked about earlier today, and continuously evaluated, recognizing that families are a resource for one another and the community. The Child Abuse and Neglect Reporting Act is located in the California Penal Code 11164 through 11174.3. In a nutshell, mandated reporters are defined as individuals who, within the scope of their jobs, must by law report any knowledge or reasonable suspicion of child abuse or neglect to a child protective agency. Some examples of mandated reporters include public and private school teachers, teachers' aides, instructional aides, health practitioners, such as those who at Palomar Health Medical Center and beyond, and law enforcement, of course, also clergy members. We have 2 protective agencies in Child Welfare Services. We have Child Welfare Services, and our numbers are there on the screen, and then also law enforcement. As to who would be best to report to first, it depends upon the circumstances and the allegation a child has disclosed. It may be more appropriate to contact Child Welfare Services hotline either before or after calling 911. Some examples of when you might call 911 might be a child presenting with severe physical injuries or witnessing a child being seriously physically abused. It's important to keep in mind that calling Child Welfare Services as soon as possible. The quickest that we can respond is 2 hours, and whereas law enforcement can get out there a lot quicker. So, of course, if it's an imminent situation, you want to call law enforcement. The Child Abuse Hotline. After you call the Child Abuse Hotline and speak to one of our social workers, their responsibility is to gather as much information as possible about the child, caregiver, relatives, extended family members, and the incident, of course, that happened, the who, what, when, where, and why. And all of this information is evaluated by the social worker to determine if it meets criteria for an investigation, for an in-person investigation. And we'll discuss what that criteria look like. as we further into the presentation. Looking at who files, of course, you want the person who has the most information to file the report. When there's 2 or more mandated reporters who are present and aware of the knowledge of the child abuse, you want to select one person who's going to make that report, that telephone call to the child abuse hotline. And then just knowing we only need one written report from an agency that's making that report. Also important to note that any employer may not impede or sanction employee for making a report. And then keeping in mind too that the identity of the person making the report is kept confidential, recognizing that trust relationship between the patient and the client, or the customer and the client, is kept confidential. Always in keeping in mind to report suspicious disclosures of abuse and neglect, remembering that you're legally responsible for reporting abuse or neglect. The hotline cannot take reports of abuse of anyone who is 18 unless there is a current minor victim. Even if the abuse occurred when the now adult was a minor, the hotline cannot process this. A common exception is sexual abuse, but again, there must be a current minor victim. If the abuse is a dependent adult or someone who is 65 years or older, the report should be made to APS, which is Adult Protective Services. Historical abuse may be reported, even if the RP believes this has already been reported. Unless their agency or your agency has reported this abuse in the past, it would need to be reported again. Just keeping in mind that we have this shared responsibility to ensure that children grow up safe and nurtured. How to file, as mentioned, you would call as soon as practically possible, and then you would follow up within 36 hours with a written report, which is the Suspected Child Abuse Report, SS 8572, which you can locate by searching on Google, SS 8572, or just typing in Suspected Child Abuse Report. This is an example of the written report you must complete. You can feel free to fax or mail the report in, or while you're on the line talking to the child abuse screener, you can ask them for instructions or to set you up with how to electronically send this report in once it's completed. This is the type of information, the vital information that you would need to collect prior to making your call that the hotline screener will solicit from you. This is authorized by Penal Code 11167. When you call to file the report, just be prepared to provide this information, your name, your agency and number, the child's name, date of birth, address, apartment number, definitely looking at whether the child has an IEP, diagnosis, developmental delays, medical concerns, description of injuries or behaviors or concerns, and any relevant cultural factors of the family. Our agency is really trying to be culturally responsive when we're working with the families that come to children and families that come to the attention of our agency. So any relevant cultural factors of the family that you have, please include that in your report. This can include any such information as cultural practices of the family. If they are newer to the area and perhaps unfamiliar with the laws around child abuse and neglect, any social economic status, any religious beliefs that may be impacting the family and the children, relevant information about sexual orientation or gender identity, or any tribal enrollment, whether or not a child is enrolled in an enrolled member as a Native American, any immigration status, anything that's going to help us to be more culturally responsive to the family and be a support and to connect them with any community resources that could be a support to them. Within the County of San Diego Child Welfare Services, we're also wanting you to be mindful of anyone who has Native American heritage. As I mentioned earlier, there is an overrepresentation of Native Americans in child welfare services across the nation. And so when you're considering making that report to Child Welfare Services, asking the question, is this person, whether or not they have Native American heritage, are they connected to a reservation, whether or not they live on a reservation, or they're receiving services from an Indian health clinic or tribal TANF or temporary aid to needy families. This is very important. Once that, we obtain that information follows that child. And it's very important if you have this information to provide it to the Child Abuse Hotline. The Penal Code has identified 5 primary areas of abuse and neglect for which mandated reporters are to report. And they include physical abuse, general neglect, severe neglect, sexual abuse, and commercial sexual exploitation of children, and emotional abuse. The Penal Code, first we're looking at physical abuse, and we have some examples here. But first I just want to give you the Penal Code definition, which includes that physical abuse is the willful harming or injuring of a child or the endangering of the person or health of a child, means a situation in which any person that willfully causes or permit any child to suffer or inflict harm or unjustifiable physical pain or mental suffering, or having the care or custody of a child and willfully causes or permit the person or health of the child to be placed in a situation in which his or her person or health is endangered. Or also, unlawful corporal punishment or injury means a situation where any person willfully inflicts upon any child or cruel, inhumane corporal punishment or injury resulting in a traumatic situation. Some examples of physical abuse include the marks and bruises that are on the location of a child's body, not typically injured due to their age or their activity level. Also occurring on vulnerable parts of the body, such as the head or the torso parts of the body that is protected by the skeletal structure. Injuries that occur during domestic violence incident, unexplained injuries that do not match the explanation. And then also physical activity used for discipline that exceeds the child's age of development and leads to injury or illness, or any physical discipline to a child under 12 months of age. It's important to note that physical discipline is allowed by law. However, leaving marks and bruises are not. And so also some considerations are cultural practices that may mimic marks or bruises or physical abuse, but is not. And that is cupping, moxibustion, gusha, coining, or spooning. And so cupping and coining and moxibustion, like I said, can leave marks, but it's not considered physical abuse. How many of you are familiar with cupping? Cupping is considered just ceramic cups that are warmed and put on acupuncture points of the body and increase blood circulation and detoxifies the body. Moxibustion is the use of small pieces of moxie herb and burned on the tips of it, and also held over different acupuncture points of the body. And the heat from it stimulates these points and also increase blood circulation and draws out any impurities. When we're looking at coining on the right side of the screen, we have some linear looking lateral marks that can be indicative of physical abuse. These are caused by coins that are rubbed on the back And then also to the left, we have Mongolian spots that look like and resemble bruising. But these are ancient Western Chinese medicine or treatments that may, look like physical abuse, but is not. These are cultural practices that leave marks that is an acceptable form of treatment. Looking at general neglect, the Penal Code defines general neglect as negligent failure of a person having the care or custody of a child to provide adequate food, clothing, shelter, medical care, or supervision where no physical injury to the child has occurred. General neglect also includes access to adequate mental health treatment. It also includes failure to protect a child from someone who is known to have harmed the child, or there's reasonable suspicion they will harm the child, or involving the child in criminal activity. Some of these we have lack of supervision based on the maturity level, developmental ability of the child, or children going to school repeatedly with inappropriate clothing for the weather. Some of the cultural responsiveness pieces that we want you to keep in mind is that in some cultural groups, they may not purchase food in large quantities and have access to it all day, but may, instead purchase smaller quantities for breakfast, lunch, or dinner. Some children prefer also to wear clothes over and over again. Sometimes they might smell or be torn or tattered. Just being mindful that this may not, be neglect, but the child's preference. And then also noting that different cultural groups have varying degrees of what's considered appropriate supervision while children are outside playing. So we just would like you to just be mindful of these different cultural practices when you're working or different children come to the attention of you within your agency or hospitals. Severe neglect, there is a different legal requirement for what is defined as general neglect versus severe neglect. The Penal Code for severe neglect is that negligent failure of a person having the care or custody of a child to protect the child from severe malnutrition or medically diagnosed non-organic failure to thrive. It also means those situations of neglect where any person having the care or custody of a child willfully causes or permits the person or health of a child to be placed in a situation such that his or her person or health is endangered. Some examples we have here are that diagnosed malnutrition caused by a parent, instances where the child's health or safety is in danger, such as a child wandering outside and being, struck by a vehicle due to lack of supervision, a caregiver driving recklessly or under the influence with a child in the vehicle, or a child left in a vehicle during extreme temperature conditions that lead to severe injury or can lead to their demise, or situations where a parent is breastfeeding while using substances. Looking at sexual abuse, from July 2015 to June 2016, about 18% of the investigations that were conducted were in response to sexual abuse. Some of the examples that we have here is any sexual act on a child, including fondling, rape, oral sex, sodomy, incest, any known or highly suspected sexual abuse, perpetrator living with a child, children exhibiting sexual behavior outside of normal exploration or that involves coercion or violence, engaging the child in pornography or involving them in obscene scenes, or adults allowing children to see sexually explicit material, witness sexual acts, or hear sexual language that is for the purpose of sexual gratification of the adult. Some tips that we want you to keep in mind that it's extremely important to minimize the trauma a child experiences in disclosing sexual abuse. Ensure that they do not feel they need to say or do anything differently, that do not extensively interview the child regarding the details of the abuse. to be careful not to have more than one mandated reporter speak to the child about the disclosure or the concern, and not to notify the parents or caregivers of the disclosure, protecting the child, and reporting the information using the same words and terminology used by the child. Looking at commercial sexual exploitation of children, we have the definition. CSEC is a form of human trafficking where sexual abuse of a child is exchanged for cash or something of value. And this type of abuse has been gaining more oversight, awareness, and laws in recent years. Some of the risk factors or warning signs is a history of abuse. Running away from home makes a child more vulnerable. Homelessness, poor school attendance, especially on Mondays and Fridays. Just being absent from school, and it comes to your attention as being problematic. Substance use, interpersonal violence, criminal history, relationship with much older adults, sending and receiving sexual explicit material via the phone, the computer, or social media. Also looking at emotional abuse, which constitutes several types of behavior that may be occurring in a household. The penal code definition for this type of abuse is the willful harming or injuring of a child, or the endangering of the person or health of the child. Means a situation in which any person willfully causes or permit any child to suffer or inflict thereon unjustifiable physical pain or mental suffering, or having the care, custody of any child willfully causes or permit the person or health of the child to be placed in a situation in which his or her person or health is in danger. This can include any bizarre or cruel behavior that is caused by the caregiver's actions. A caregiver being extremely verbally abusive, manipulative, isolating of a child, or behaving in some cruel or bizarre manner that causes the child to have their own mental health concerns, including here severe anxiety, depression, with withdrawal or aggressive behavior towards self or others. Also, domestic violence is considered emotional abuse. This is whether the child is present or not present in the home. The child has witnessed or was involved in a physical altercation between the adults in the home. Some questions that you could ask that might be helpful when you have this type of allegation, or were the children home? Where were the children during the domestic violence? Or did anyone have injuries? Or is there a history of domestic violence? Or was anyone arrested? Or was the police called? So these are just some example questions that you can ask to just get more information. After the report is made, after you've called the child abuse hotline and you've made your your telephone call, and they, the hotline will take the report and they'll assess it to determine if the report meets criteria for an in-person assignment and investigation. While they're on the phone with you, they're going to be utilizing a screening and response priority guidance tool to determine if the report meets criteria and warrants this investigation. Some reasons why it wouldn't be assigned include historical information. The alleged perpetrator no longer has access to the child, a duplicate referral, or there's already a current investigation, and it just doesn't meet the penal code criteria for an in-person investigation. A screener may also cross-report to law enforcement or another agency that may have jurisdiction over the child. I had noted earlier that if it's someone who's older than 18, we may report to Adult Protective Services. There are also times that we may send information to animal services if there are animals in the home, just for example. We'll also send mandated reporters a feedback letter after we've completed our investigation called the mandated reporter letter, letting mandated reporters know basically that we've conducted the investigation and how it is closed, whether it's unfounded, inconclusive, or substantiated. These are our response times. Within Child Welfare Services, we have, of course, our 24-hour response time, and within that, we have our 2 hours. I mentioned earlier that our earliest time that we can respond to any report of child abuse and neglect is 2 hours. And then also we have a 5 and a 10-day response. 5 or 10 days response are allegations that still require an investigation, but circumstances allow for a less immediate response. Occasionally, a referral may be preliminarily assigned to one of our 6 regions for investigation, and the worker or supervisor may contact you as the mandated reporter for additional information, and they may determine that a response by a social worker is not warranted at the particular time that they have it, and it might be evaluated out. This is our case flow within our agency. You see the red circle at the very top of our case flow. That represents the hotline. That is the entry point for our agency for any referrals or cases that we are working with. And that allows us to make that in-person contact with, once we receive that referral and it meets criteria for in-person contact, that allows us to make that contact with people in the community. At the hotline, a referral can be screened out, for the various reasons that I had spoke to earlier, whether or not it's a duplicate or a historical referral, or if there's a current investigation going on, it could be screened out or evaluated out at that time. If it's assigned for investigation, it'll be assigned to one of our 6 regions within the county, which is Central, North Central, East, South, North Coastal, and North Inland, based on the parent's address. And so it'll be assigned for investigation, and it'll be kept open for a period of 30 days. Once the investigation is completed, a couple of things could happen. It could be closed altogether, or if we have a substantiated referral, once we have a substantiated referral, we can also offer voluntary services to the family if the family needs additional support and services. But it is voluntary, and the family would have to be willing to participate and receive those services. If not, then we would close that referral. But if the family is open to receiving those voluntary services, we'll work with them for a period of 3 to 6 months. And at the end of that, it would close if no further intervention is needed. And there are instances when we have a substantiated referral, it's very high risk. We will seek juvenile court intervention, and we will have an initial hearing called a detention hearing. And at that hearing, the judge will hear all of the evidence presented by our social worker via our agency, and the judge could look at our evidence and look at on the surface of things. It looks like abuse or neglect has happened, and they could, if it doesn't look like abuse or neglect has happened, then it doesn't meet the Welfare and Institutions Code level of intervention, they can dismiss the petition. Otherwise, if it does meet the level of the Welfare and Institutions Code and the judge does believe that abuse or neglect has happened, they will set a jurisdictional disposition hearing in about 24 to 30 days out. And at that hearing, hear additional information that the Child Protective Service social worker has gathered through their investigation and provided in their jurisdictional report to the court. And at that time, the court may make a true finding, and the child can be declared the dependent of the court, and the court can then order court-ordered services for that family, which is the continuing services, which might be family maintenance, providing services to the children in their home with their parents, or if situation requires that child to be outside of the home, the court would order family reunification services. And then there are some occasions when the court may go straight to a permanency hearing if the parents' whereabouts are unknown, or in situations where parents have failed to reunify previously, and it rises to a level where the court would just offer permanency services to those to the children, which would be guardianship or adoption. And so this is our case flow, and if you have any questions, let me know and I can clarify those at the end. This is a pyramid chart. This is 2018, 2019. I apologize that this isn't more updated, but I do have the 2020, 21 statistics. I just want to share with you all the number of calls that we get through our child abuse hotline. For 2021, we've received 36,000 calls or reports that were made to the hotline, representing 62,000 children. Of those, 19,000 of those reports, including 36,000 of those children, were assigned for investigation. About 408 were new voluntary service cases were offered to families, and about 1,000 new petitions were filed on behalf of children. In regards to the other information that's on this statistics chart to the right, we have the ethnicity of children in referral. Those numbers haven't changed so much. When we look at the disproportionality of African American, Latino, and Native American, they are represented in our agency at twice their population, their number in the population in San Diego County. And so just moving forward, this is just a reminder that it takes all of us to keep children safe in familiar environments. The work that we do together make it clear that it really does take a village to raise a child, and it's our job to work together with the families we serve to develop plans that ensure their extended family, friends, and the community, ensuring that children do grow up safe and nurtured. And we simply couldn't do it all alone. Thank you so much for your time. And now I'll just go ahead and open it up to questions.
Thank you so much, Lynn. That was really informative, and I have to say I really appreciate your emphasis on cultural needs and being able to interpret what's going on there is sometimes isn't always interpreted correctly. So that's important. I wanted to ask, is there anything, like, this is really informative as far as trauma-informed approaches, both you and Marnie shared about how to address things that come up. Do either of you have any input about ways that clinicians can promote healthy relationships in the home and boundaries for kids?
Definitely. I know when we're working with families, one of the things that we do is we're often utilizing parenting resources that are in the community, like say San Diego or First Five, First Steps, or UPAC, or different community programs to help work with family, like coaching programs or peer support programs are very helpful in just referring families when they're talking to you about just not knowing how to parent, or they have some questions, giving them those referrals, that one pager or a little handout about different services that are available in the community. 211 is a great resource to give to families, or if you have a one pager with some childhood tips, that would be helpful to give to parents as well, to help guide them in their journey as parents.
Thank you. Okay, so does anyone have any other follow-up questions?
Oh, thank you. My people, my people. You know, it's interesting that you asked that question because, and I see who that is right there. My people they hail from Texas. And of course, I'm an African American. So, um, my people they are ex-slaves and sharecroppers, and they come from Africa. And because my people were slaves, I do not know exactly where I come from, but I do have my my kit that I want to do at some point so that I can find out more about my ancestry. But I'm proud of my people, being an African American, and I thank you for that question. Definitely hugs. um, let's see, any other questions? Some of the tips we have as far as like, running away from home, you know, um, just when we're looking at, our CSEC, population, I know that it's just mindful to be aware of the different warning signs that we put out there about, if you're listening to young people, and you know that as you're talking to them and you're gleaming that they, have run away from home, knowing that that is a big risk factor. For these young people because they're out on the street, or they might be at a bus depot, or they're just walking up and down the street. That's a huge risk factor for human traffickers to target them because they're vulnerable. They're out there on the street, and they might want to do anything to get a few dollars or to get off of the street. And also looking at the fact that, if they use substances, that might be something that might lure them into being, into human trafficking. I know that when there's a question on there whether or not there's any marks. I mean, I know that some victims of human trafficking, they may have their pimp's tattoo on their body. That might be something that that you want to look out for. If there's a tattoo of someone's name or branding or something that's on the young person's body. Are there any other questions? Take a look here. I don't see any other questions. Is that it? Are there any other questions?
Did you have your contact information in your slides?
I didn't. Let me just put that in the
chat. Yeah. And then we can, if they have follow-up questions, we can include that in the minutes.
Okay.
Trish has a question for Marnie. What recourse does a victim have if a medical mandated reporter does not report or otherwise feel it's not a reportable situation?
So I want to make sure I understand that question. Is the question if the doctor doesn't want to report it to law enforcement, but the victim wants it reported, what can happen?
I think that's correct. Trish,
I can give you a little bit of detail. Is that the victim went to a medical emergency room here in the county with an advocate who was told to be removed from the room, but they wanted this to be reported. The nurse and the doctor, yes ma'am, refused to report because they didn't feel it fell under the mandated reporter rule, and it was a sexual assault. What recourse does that victim and or advocate have?
So I don't know that they have a recourse towards the physician, but the victim has every right to contact law enforcement herself. And I know that we have Patty Wrinkle on, who is one of our Palomar forensic nurses. I know she can address the issue that the victim can get a START exam, and she can get an exam that can either be reported or she can request that it that she does not want to participate in any law enforcement prosecution. But the victim has every right to report any crime that she wants to law enforcement. So the victim has the power to file that report with law enforcement, of course.
All
So
right.
the misdemeanor that a clinician can receive for not reporting, how does that happen?
I've never seen that prosecuted. And if the clinician does not feel that there is a suspicious injury, I think they have to first feel that it is a suspicious injury before the duty to report kicks in. If they don't feel that it is, then they would not have a duty to report. So I think this may be getting conflated with an earlier question we had about, is there a requirement to mandatory report human trafficking? And my response was, with regards to suspicious injuries, if there's a suspicious injury associated with human trafficking, if there's a suspicious injury associated with a sexual assault. Sexual assault doesn't always have a visible injury. Strangulation doesn't always have a visible injury. And so the presentation that I gave was specifically with regards to suspicious injuries. Some of those crimes, a lot of them would necessarily have a suspicious injury. Some of them might not. And so those rules apply if there's a suspicious injury. If there's not a suspicious injury, per se, that doesn't address the horrible emotional trauma that maybe a person is experiencing. That doesn't mean that the victim doesn't have the right to report. A victim has a report. Every victim, every person has a right to report anything that they feel is a crime. So they have full access to report to law enforcement. I think we would be getting into tricky territory towards whether or not a mandatory clinician reporter has a duty to report. If they don't feel there's a suspicious injury, then I don't believe that they have a duty to report. So it sounds like we're hearing there's a sexual assault that's been reported. There wasn't a suspicious injury associated with it, but that doesn't mean that the victim doesn't have the recourse to follow up and make that report, and she's entitled to a forensic exam if she wants one. Does that help? Am I understanding the question right, and am I tracking the concern?
You're understanding it correct, but understand being traumatized from the rape, from the assault. They don't even know their own name, so an advocate would be there to assist. But I think
Right.
And Shlyn, with older minors, sometimes they're reluctant to report. And do you have any tips as far as like how to maintain that relationship of trust with a minor when there's a mandated reporting situation?
So I do know, and this is of course working with, again, people that are smarter than me, like Patty, that children ages 12 and up can consent and request their own forensic exam. They don't need parental permission to do so. So the child can do that on their own if they're 12 and up. And is your question how to maintain a relationship with a minor who does not want a suspicious injury reported? Is that right?
Yeah.
So again, I think that the out always, when there is a suspicious injury and there is a mandatory reporting situation and a person who's obligated to report feels that they have a duty to do so, and a patient, especially a minor patient, does not want that reported, I think it's important for any patient, including a minor, to understand there's all kinds of reasons someone cannot want something reported. They could be worried, especially a minor. They may have been in violation of a parent's rules to be in the position to be injured, i.e., they're out at 2 o'clock in the morning and they snuck out of the house and they don't want their parent to know, because otherwise, if the parent knows they've been injured, then the whole thing blows open. I think one of the things that I do when I'm working with children There's a phrase that I hear thrown around by lots of folks in normal parlance, which is, oh, they're just a kid. I don't like that phrase because it connotates that a person who's just a kid, that their feelings and concerns are not as valid as an adult's, and they are. I don't care if they're two. I raised children, and I had 2-year-olds crying because we can't go to the park because it's raining and you promised. And for me to say, well, that's silly, I don't control the rain, you need to get over it, does not acknowledge that I have a 2-year-old who's upset and doesn't understand. And it's important to understand. So making sure that a minor patient understands that their feelings, their worries, and their concerns are every bit as important as anybody else's, and maybe getting at the root of what are they worried about, understanding that their worries and their concerns are valid and they're going to be listened to, that we still have to make the report, but how they feel, even as a minor. When tomorrow, I have a district attorney interview with a molest victim, and their father's coming, and I'll meet privately with the detective and the minor victim. And I will tell that victim, I need to know what you think before I do anything. You've talked about and been very brave to report someone abusing you. I'm now going to be making some decisions that will impact you greatly. I don't want to make those decisions without first asking you, outside the presence of an adult, just you. I want to know what you think. I don't want to make these decisions without hearing you out. So I think if they are acknowledged that they have fears, worries, and concerns, we may not understand what they are because we're grown ups and we're no longer in the mind of a 12-year-old. But if we listen to those and let them know, just like anybody else, whether they're a minor or not, what they think and how they feel, we're obligated to listen to that before we do anything on our end. I think that's always a good fallback position, because I think when anyone says law enforcement or the DA's office is going to be involved, the immediate fear is there's going to be retaliation, someone's going to dangle me, I'm going to be in trouble, someone's going to go to jail. It's important to know what the fears are, and then let them know someone is going to be listening to those fears before any action is taken in the criminal world. If that helps.
And Shlyn, do you have anything to add to that?
No, I think she did a great job. Thank you.
Are there any other questions for our presenters? We really appreciate your time.
Thank you so much for the opportunity.
So I think we'll go ahead and end the recording.